Okay, well, as I see all of our attendees popping into the room, we're going to wait as we normally do, just a minute or so to let people log in, let people get in here. I'm very excited to talk about this today. It's become one of those things, every year that goes by, you enjoy certain things in life more and more. And copyright registration, oddly enough, is one of the things for me. So I'm very excited to talk about it today. Also, very excited to have Jim Datri with us, ASMP's CEO. Oh, you're seeing a cameo from my Great Dane in the background who may be wandering around. So he will only make noise now that we've started. So why don't we do this? Looks like we have a pretty full room. Jim, I'm going to throw it over to you and let you get started.
Thanks, Tom, and hello, everybody, and welcome. I know many of you, if not most of you, know Tom, but for those of you who do, and for the few of you who may not, I wanted to take the opportunity to give an introduction because we're so lucky to have someone of Tom's caliber and experience with us at ASMP to provide all of you, our members, and this is a members-only event, with a level of expertise and training and knowledge that I truly believe you can't get anywhere else. So one, I'm grateful to have Tom with us at ASMP. He's got a unique background. I, as you know, I'm a lawyer, but Tom is, of course, a lawyer, but there are very few lawyers who are both creatives and attorneys at the same time, and Tom is that. And impressive at both. Tom got his Bachelor's of Arts in Commercial Photography from the Brooks Institute and was a working photographer and created a successful photography business, but then became a lawyer. And in addition to having a business degree from University of Texas at Dallas, he has a law degree from SMU. He's a member of the bar for 4 federal circuits and the U.S. Supreme Court. Involved in cases and issues that come before the U.S. Supreme Court. And yet we have him available with us here at ASMP. He's on the board of the Dallas Opera, the board of the Arts Council of Texas. He's a member of the board of the Copyright Alliance in Washington, D.C. He's a designated representative for the Authors Coalition of America. So a long list of involvement in both things that are on the artistic side and the legal side. And he marries those two things together to provide us with the expertise that we're lucky enough to have at ASMP. He works with collectors and museums across the nation. He works with folks who are setting up their businesses. So he has expertise in startup law and entrepreneurship. He works with people, which we're talking about today, protecting the copyright to their work. Works in trademark law. So a large cross-section of expertise that both helps people grow their businesses, start their businesses, and then protect the work, the things that they create once they do, all of which is completely core to what ASMP is all about. And again, the place to see Tom is here at ASMP. Tom, I hope you don't mind that plug, but it's the case, and we're very proud of it, and we're super lucky to have him. And Tom, I'm going to pass it to you for the presentation I know everyone is eager to get to.
Well, thank you, Jim. Thank you for the kind introduction. It makes me excited to hear all the things that apparently I do. So I'm very happy to be here today, of course. So today we are going to talk about copyright registration and 5 things that I think are critical for anyone who is registering copyrights. I'm going to quickly go over to a presentation and we're going to spend a little bit of time. I'm going to do a quick screen share where we're going to log into the Copyright Office, but this is not a comprehensive seminar. When we do the copyright in-depth classes, we just did a 5-week workshop here at ASMP on copyright. And so today I'm going to hit some things that you've probably heard about and might have some questions on. And I bet one or two things that you might not have ever heard about in relation to copyright registration. There's going to be a poll that I'm going to turn live in a little bit that just has 3 questions on it about copyright registration. Definitely love to get a sense of where you're at. And then at the after we finish the presentation, which should take 15, 20, 25 minutes, we're going to come back. Jim and I are going to talk for a little bit and answer your questions. If you have a question, please put it in the Q&A box. Q&A box right down there at the bottom. That's going to be the best way to see them. You could put it into chat. There's a good chance that we might see it, but not a 100% chance. So put those questions into the Q&A box. That allows Jim to see the questions and read them off so that I can do my very best to answer them. So let's go ahead and get started. I'm very excited to have so many of you here today. I'm going to go ahead and share my screen. And I certainly hope that everyone can see that. If it doesn't look good, if something's not going right, put those messages into chat so that we know that things are looking good or not looking good. So, as I mentioned, the 5 things to know about copyright registration for photographers. And as Jim mentioned, very excited that this is an ASMP members only webinar. I think you're going to see more of those in the coming months. We really want to take some of the information that's so very critical and make sure that all of you who support this organization and who spend your time and energy and money making it go really have access to the most up-to-date, best info that's out there. First thing, if you go to this link, and you can grab that QR code or you can go to this link, you will get a download of a zip file that has 4 documents in it. One of them is a court case I'm about to mention, which none of you have to read, but is there if you're interested in it. It's a Supreme Court case on copyright. Another thing that's in there is this presentation in PDF form for you. And then the final 2 documents are the spreadsheets that the United States Copyright Office uses, their templates. So I put a copy of those templates in there for you. So again, I'm just going to stay on this page for one more second. You can grab that QR code with your phone. You can type in that URL. Be aware, everything is in all caps. Do it that way. We made this one in all caps, okay? So do it exactly like you see it there, or grab that QR code and you will get all this info. I'll put this back up at the end so that everyone can access it. So why registration is so critical is where we're going to start today. And let me start by saying, and this is my own personal my own personal project, and that is 2021 is the year of registration at ASMP. There are lots of other things that are going on, but I am all about registration, and this is the first of many, many registration things that we are going to do. Why? Why is registration so critical? Well, if you want to enforce your rights, you have to have registered your work. Now, there's a Supreme Court case that I put into the folder there. It's called Fourth Estate Public Benefit Corporation versus wallstreet.com. And it was decided in 2018. And essentially what it says is you cannot file a lawsuit in court to enforce your copyright. Someone infringes until you have that registration certificate in your hand. So you need to register if you want to enforce your rights. But that begs a question that I often get, and that is, well, if I don't register, then does that mean I don't have these rights? It's an interesting question, and one that we're not going to dive into a whole lot, except for me to answer it in one sentence. And that is to say, the minute you press that shutter, the minute you take that picture, you own a copyright in your photograph. You don't have to do anything. You don't have to tell anyone. If you've been to my copyright classes, you probably have heard me say that 100 times. You own a copyright from the minute of creation. And for photographers, that's the minute you press that shutter. Okay, so what does that mean, and why are we talking about this extra step? Because if you want to enforce your rights, if you want to make someone stop doing something, you have to have your works registered with the Copyright Office. First reason to register, you want to enforce your rights. Another reason, do you want to be eligible for statutory damages? You have to register. When you go to court, and we're going to talk about the Case Act in a second, but when you go to court, you can elect actual damages or statutory damages. Actual damages or statutory damages. And actual seems pretty simple, right? Actual is how much money did I lose from this infringement? And, so you lost licensing fees and you lost residual income, and, the person who infringed made money off of you, and so you can cover that. But what if the amount that you lost was like really not very much, but you were still infringed, right? So there's this other type of damage. It's called statutory damages. And in the Copyright Act, it says you can elect statutory damages, where it's up to $30,000 per infringement for normal infringements, and up to $150,000 per infringement for willful infringements. And what this means is that, let's say someone infringes you and they put it on some website, and that website no one ever goes to. So literally no one saw it, right? You are still eligible for statutory damages, even if actual damages would essentially be $0 or $5. But you can't get statutory damages unless you register your work and register it timely. Really important to register to get statutory damages. Now, we've talked about the Case Act so many times, but do you want to take part in the Case Act? Well, you have to register your work, right? You have to register those copyrights. Just like regular court, the new Copyright Claims Board, which was created with the passage of the Case Act, requires you to have already registered your work before the actual hearing is held and the determination is made. Okay. So 3 reasons, not all the reasons, but some of the reasons to register. I could spend my whole time talking about reasons to register, but let's talk about the tips, right? What today is not comprehensive. Already talked about that. To get comprehensive on copyright, this is where it's going to take a lot of time and a lot of effort, but we got some things coming up that are pretty exciting. Not legal advice. Look, I'm going to give you my 2 cents on this thing, and I spend day in and day out on copyright matters. But this isn't formal legal advice like you'd have if you have your attorney and you're sitting across from them and you're in that attorney-client relationship. Everyone's situation is different. Copyrights can be super tricky. There might be all these things like work for hire and everything else. So take what I say, file it away, use it when you're registering. But remember, if you want that exact legal advice, you need to be working with an attorney. These are the things that I think are important, but they're not the most important things. They're not, and not everyone agrees the 5 things I'm going to mention are top of the list. But I want to say these are just things that I think everyone should know. And this program is not a substitute for getting in there and doing the registrations, right? Just knowing about something is great. I love reading. I love learning things that I will never do. I love learning about, but this is not that. This is, you got to get in the trenches here. You got to register your work. Okay. We got some walkthrough videos coming that I've been working on lately that are going to come out in March. They're going to be really detailed, available to ASMP members for free, where you're going to get as much information as you could want on the new copyright registration process. And I think this is kind of a good little introduction to what you're going to get with some of those videos coming up soon. Number 1, 5 tips. Number 1, sort and name those images. Sort and name those images. It makes your life so much easier if you have a workflow that organizes and names your images in a way that aids registration. Now, when I was shooting, I use Lightroom all the time and still do for the ways to organize my images, right? And so I actually, in relation to copyright, did 2 things. 1, I had a keyword system so that I could type in certain keywords and figure out what was registered, what was not, what was considered published, what was not. I also had, I used some of the color labels for that as well, so that at a glance, I could determine what photos I'd registered and what photos I hadn't. It can get a little tricky unless you are keeping all these spreadsheets and everything else and you have a good system. Once you do 3 or 4 registrations, it sometimes can be hard to figure out, well, what did I register and what didn't I register? If you're starting fresh, if you're getting going on all this stuff, create those keywords, create those color labels in your programs to really identify what's been copyrighted and what hasn't. Ensure that you know when the work was created and, if applicable, when the work was published. We're going to talk more about that in a minute, but you always want to have some dates in there. And, if you're going back 10, 15, 20 years, it's hard to come up with this stuff. So you want to have these notes in there. You want to have these in the keywords. You want to have them in the metadata, whatever system you use to keep information you want to have there. I'm a really big fan of written checklists and written workflows. I'm going to show you some of my workflows in some classes that are upcoming, where you can see the actual ones that I used when I was shooting many years ago and the ones I use now when I register. Just like pilots, they know what they're doing and they've done it a million times, but you go down this written checklist, you make sure you get everything in the right place, and then you can sleep easier at night. Okay, tip two. What is a group? What is a group? Okay, so 2 types of groups, right? The US Copyright Office has created 2 ways for photographers to register groups of images, up to 750, okay? Now, if you've been registering your work for a while, you'll realize that there used to not really be a limit for registering unpublished photos in a collection, is what they called it back then. But now we have 2 things. We have a group of published works, group of published photos, and a group of unpublished photos. Each of them have a 750 image limit. There you go. Those are our 2 options. Here's the criteria. For a group of unpublished photographs, they all have to be unpublished. Okay? They all have to be created by the same author, and they all have to be owned by the same copyright claimant. Okay? So this means that the same person has to have taken them, and the same person has to own all the copyrights. Now note, the claimant and the author don't have to be the same person, but you can't register a group where you have multiple authors or multiple different claimants, okay? So you have to have all the same author and all the same claimant, but they all don't have to be the same person. Now, for a group of published photos, 3 things, just slightly different. They all have to be created by the same author. They all have to be owned by the same copyright claimant, and they all have to be published in the same calendar year for the first time. So let me illustrate this with an example. I do a lot of photography of concerts, right? And I always go to concerts on New Year's Eve, and I always take pictures on New Year's Eve. And the pictures that I take before midnight have to go on a different application than the pictures I take after midnight. It's crazy, but it is about calendar year, okay? Calendar year. So even though that's one shoot, even though it's within the span of 10 minutes, same thing, I'm photographing, they have to go in 2 separate copyright applications if they're published, right? And this has to do with the year of first publication, okay? Now, you can shoot them, you can do a couple different things with them, and we're going to talk about what is publishing here in a second, and you're going to get to why I worry about some of this stuff here. All right. So, and I noticed we have some questions coming in the Q&A. Very excited about that. And I'm going to answer one of them here in a minute. You cannot mix published and unpublished photos on the same application, right? You cannot mix published and unpublished photos on the same application. I have been working on cases very recently, and this comes up all the time, okay? You want to really determine what is published and what is unpublished to the best of your ability, which leads us to point 3. What is publishing? Okay, so here is the truth of this. I feel like in the photographic world, I can easily get on the phone with the 3 or 4 people who are the most knowledgeable about copyright law and whether something is published or not in photography. And we don't always agree on things because this is tricky. This is really, really tricky. It is simply the most confusing question in all of copyright registration. Okay, very confusing. Now, as a little aside, let me say, I was working this week on the Copyright Office Modernization Act. And one of the things that we're asking for from the Copyright Office is better definitions on these things and better examples of these things, okay? And it's going to be a big push this year to really make sure that we have better understanding here. So let me give you a few examples. We're going to look at something the Copyright Office says, right? And then I'm going to kind of wrap it up with, leaving the ball in your court to an extent. If the work was never offered for sale to the general public and it was posted to a private social media account, then it's likely not published, okay? It's not published. I'm just giving 2 examples. I'm going to get into more in a minute, okay? So that's one end of the spectrum. The work wasn't offered for sale. It's on your private Instagram where you have to approve friends, okay? If the work was posted on your website or a social media account that's public, and there was a caption or somewhere in your bio or somewhere on the page it says that these images are available for licensing or sale, then likely it is considered published. Now, everything else that falls in the middle is a gray area when it comes to publication online, okay? Which means, what if I put an image on my personal Instagram account that's open to the world? Is that published? Well, if you don't have anything in your bio or in the caption which says it's for sale, then maybe it's not published. But what if you put it on your commercial public Instagram account where, there's a link to your website where people can buy your work? Well, then it likely is published. But what if you don't sell the individual images and you're just using them for public display to show that you're good at things? Well, then it's actually likely not published. Can you see where this confusion comes in? It's a mess, okay? So let's try to clear it up a little bit more. Here's what the Copyright Office says. Copyright Office says, this is the definition from them. For copyright purposes, a photograph is published on the specific month, day, and year that a copy or multiple copies of that work are distributed to the public for the first time, period. So, first sentence, it's published on the specific month, day, and year that a copy or multiple copies of that work are distributed to the public for the first time. Second prong of this, a photograph is also published when copies of that work are offered to a group of persons for the first time for purposes of further distribution or public display. The public display of a photograph in and of itself does not constitute publication. All right, 2 tricky parts here, right? The first one says, on the day, month, and year that a copy or multiple copies are distributed to the public for the first time. Well, what does distributed mean? And if you're looking for an answer from me, you're not going to get one. Does distributed mean that it goes on social media? Does distributed mean when it goes on your website? Does distributed mean when you actually send someone a file? Well, yeah, I think we can agree that sending someone a file is some kind of distribution. But what if you're just sending it to one person and they're not allowed to do something with it, right? Because that second prong talks about being offered to a group of persons for purposes of further distribution or public display. And that's equally tricky, okay? What does further distribution mean? If I send my work to a client, have I now, and my client's a magazine, have I now sent it so that at the moment I send it, I've sent it to a group of persons for further distribution. Well, that's kind of part of the job. Does that mean that it's when I send proofs that it's published? I don't know, a little tricky, right? What about if I send it to someone who's going to put it on display somewhere, right? But a group of persons, what does that kind of mean? Okay, I hope you can see where the trickiness is here, okay? So here, and I note a question that just came in that hopefully this next little bit will answer. Here's what the Copyright Office says, and there's a person up there named Rob Kucinich. He's the Director of Registration Policy and Practices. So this is from the horse's mouth as much as we can get. A group of images were licensed to a client, but only 2 of those images actually appear in print. The distribution of the photographs to a client could, in itself, constitute publication in the legal sense. The office would accept this position from an applicant. So what is he really saying there? Well, let's say that your client licensed some work from you, but you don't know if they ever used it or not, or they only used one picture, and that was the one that was used for further distribution. Does that mean the other ones were not published, right? Well, I don't know. What Rob is saying is that you could consider them all published. That once you send it to your client, whether the images actually appear in print or not, you can still say that these were published, even if, frankly, they were never published, okay? And published in the sense that we think about when we talk about publication in the real world, not copyright publication. There are a million little tricks here, and I know we're going to get a lot of questions on this, and so I'm going to hold some of this until we wrap up this little bit, okay? But what I want you to think about with publication is the intent of you putting the work out into the world. Are you intending to put it out there to sell it? Are you intending to put it out there to the general public so that it can be further distributed or passed around or purchased or licensed? If so, published, definitely published. Are you being very restrictive about how this can be used in the world? Are you putting it on private accounts, or are you saying that this work is not for sale? You know, things like that. Then it might be considered public display and be considered unpublished. Tricky stuff, I know, and I'm sorry. And this is why we fight for these things. Okay. Number 4, let's give our brains a break from whether or not something is published or unpublished and assume for the minute that we have categorized these two groups of pictures. And now we're going to go register the work. We're going to go register the work. Part of the new copyright application process with groups of published and unpublished images says that you have to provide a sequentially numbered list of what you're registering, right? And the Copyright Office, nicely enough, gives us 2 templates. One for groups group of published photographs and one for a group of unpublished photographs. They're slightly different, and we're about to look at them. If you go to that QR code or that bit.ly link at the beginning, you will see these templates in that folder. So a list of images with certain information is required by the USCO. Use the ones that are there. I see people try to make up their own. No reason to do that. It just increases the chance that something bad will happen. Use the templates that come from the Copyright Office. There are 2 separate templates, as I mentioned, one for published and one for unpublished. So make sure that you're using the right one. For groups of published photographs, you have to provide the title and the file name, and those can be exactly the same. You also have to provide the month and year of publication, okay? The month and year of publication. All photos must first be published in the same calendar year, like we discussed a minute ago. For groups of unpublished photos, then you really only have to provide the title and the file name. And again, those can be the same. You don't have to give a special title to each image. The name that comes out of the camera or the name that you get after you run it through Photo Mechanic or any kind of renamer, however you do your naming is just fine. Again, see tip 1 for talking about naming these things to make it easy for you. Now, these are a little hard to see, and we're actually going to look at them in real life, but I wanted to just put these up there for you so you can see what these look like. And I will share my screen with those in a moment. This is the one for published photographs. You'll notice different colors, and that is column 1 is the photograph number. Column 2 is the title. Column 3 is the file name. Column 4 is the month and year of publication. And then column 5 and column 6, you don't fill in. It does it automatically, okay? So photograph number 1, I called this one Y, and then it's y.jpg, and I put in the month and year of publication. The spreadsheet itself filled in the word Y and turned it green. But notice on photograph 6, which I called 2, in the file name, I left blank. In the month and year, I left blank. And that's highlighted in yellow. And on the right-hand side in that column, it says, please enter the file name and publication date. So it automatically checks to make sure you're doing the right thing. That's one of the reasons that you should use their templates. Now, these titles were not realistic. The titles spell out why is it so hard to define publication, but this one over here, this looks more like what we might use, right? Something that has a date, something that has a sequence number in it. And you'll notice here, this is the spreadsheet for the group registration of unpublished photos. So you have the title of the photograph, the file name of the photograph, the list of the group titles are generated automatically for you. And if you're missing any information, it'll be highlighted in yellow in column 4. All right. Last one before we look at a few things and then we get to questions. Get those titles in. Get those titles in. Okay, the title two-step. I'm here in Dallas. Two-step is something that you hear about here. I've never done it, but I know people who do. So this is something that very few people are doing correctly when they register or doing at all when they register. And it's not required, but in recent months, I've seen more and more reason why you should be doing what I'm about to describe. And I would bet that the vast majority of people on this webinar and the vast majority of every copyright registrant does not know what I'm about to tell you. When you are in the midst of your registration, which we're about to look at, you're asked on page 2 of it to give a title for your group. The first time you click that box, you're giving a group title. But what about the individual names? What about the individual names? If you want to have the image names on your certificate, and I highly recommend that you do that, then you have to click Add Title again, and then you copy and paste. And if you have no idea what I'm talking about, that's okay, because I am about to show you. So I'm going to stop sharing my screen. We're going to spend about 5 more minutes looking at a few screen share things, and then we're going to answer some questions. All right, hope everyone's sticking with me here. Let's go ahead and okay, I hope everyone can see this. This is the Copyright Office. I'll make it hopefully a little bit bigger so people can see it. And if you are here, you can look at all your cases, you can look at open cases, all this stuff. But what you want to look at is right here on the left-hand side in this column, and it says register a group of photographs. So we're going to click on that. Then it talks about, are you eligible to register a group of photographs? And it says you can register published or unpublished. Okay, good. So we're going to start registration. First thing it's going to ask you is the type of group, published or unpublished, right? So let's, for the moment, say published. Now, these are the things I mentioned. It has to be created by the same author, owned by the same claimant, and published in the same calendar year, okay? In addition, you must submit a sequentially numbered list, right? You should use the template. Great, I'm about to show you that. So then you click yes, and you're finally into your application. How do you know that? Here on the left, you just selected the type of group and you just go down this list. So page 2 is titles. All right, we are going to pretend that we are registering a group of published photographs. As soon as you start the registration process, up here at the top, you get a case number. Hope you can see that. It's a little small, but I'm going to copy and paste that, and I'm going to show you why in a second. So I'm going to call this, I'm going to give the group title. So the title of the group will be Feb 2021, right? And then I'll call it webinar. Okay, the number of photos in this group, we're going to say there are 8. Now you can go all the way down to 750, but we're going to say there are 8 here. The year of completion, 2021. The earliest publication, according to the spreadsheet that I had before and that I want to show you again, the earliest publication date, we'll do 01/01/2021. And the latest date we'll do 02/15/2021. Okay. Nation of first publication, US. There we go. So if I hit save, what I've done is I've created a title for the group. Now, let me show you some things. I'm going to stop sharing this screen, and I'm going to share one more screen, and we're almost done with the sharing, I promise. And so now let's look at this, right? This is my thing. Now, notice here, this is in yellow, like I said, it's not right. And so what I'm going to do is I'm going to type in 2.jpg as my file name, and my month and year of publication will be 2/21. Notice now that turns green and is no longer yellow. Okay, so that knows we did it right. Up at the top of these, you see it says insert case number here. That's why we copied and pasted that. So double click on that, and there it is. Looking good. Here we go. Last thing. Notice this column, which seems like a weird column. It's the list of all group titles. And what it does is it takes your title, which is in column 2 over there on the left, and it repeats it, and then it puts a comma. And why is it doing that, might you ask? This is why. I am going to go ahead and copy all of this. So I'm going to copy all my titles. If I had 750, I do 750. And now I'm going to go back to my registration. And I just did my group title, but now I'm going to say new one more time. And a totally different screen comes up. Okay, totally different screen comes up. Most people have never seen this screen. All right. So the number of photographs entered, remember we have 8. The month published, we're going to go ahead and say February. Okay. Now there's some, you can say help here, and it will talk about go say it's January, and it will talk about how you determine some of these things. We're not going to get into a lot of that right now. But what I'm going to do now, see where it says photograph titles. It didn't say that before. Before it said group titles, so photograph titles. I am now going to paste, and notice that it puts in my titles with the commas. Awesome, because now this will appear on our certificate, and we're very happy about that. That is something that I think very few photographers know, very few copyright lawyers know, very few people know. I hit save, and then here you'll notice that I have the title of the group and then the titles of the contents. All right. That is that. I am going to put very quickly that link, the bit.ly link, and I'm going to have Jim and I both here on this screen. I'm going to put the bit.ly link in chat so that everyone can take a look at it. Boy, all right, Jim, what do you think? Oh, you're muted.
Sorry about that. Pretty amazing. I took a lot of notes myself. It's a great presentation. We have about, well, we had 13 2 seconds ago. Now we have 15 questions. So I'm gonna organize these, and I'll not cover those that you covered during your presentation, because a number of these questions I think you answered during the talk itself. But I see right at the top, and our earliest question comes from Elizabeth, and she says, is it necessary or even good practice to register copyright for different versions of the same image, like a black and white and color version, or both or all covered by one single registration? And does it matter if the two versions were previously published?
Boy, that's a great question. That's a great question, because it goes to an idea that is in copyright law, which is derivative works, right? So as one of the rights that you have as a copyright owner, you have the right to create derivative works. You're the only one that's allowed to. And what is a derivative work? Well, there's a lot of nuance about what a derivative work is. Now, is a derivative work, let's say you have an original raw image and then you have a color version and black and white version, those are likely going to be derivative works of the original. So you don't have to re-register things on those. Those will generally be encompassed as derivative works. But what if you really start changing stuff up, or you're using stuff in a different way than you were using it before? Is it a good idea to get an additional copyright registration for the same work? Well, you have to make that determination. If the answer is it's a derivative work, then no, you don't have to. But every now and then, I will recommend that a photographer re-register an image that has been changed in such a way that it might be considered to be a brand new work. That's a very fact-specific kind of thought, but the overall answer, by and large, is no, with a few exceptions. It's not even like you'll know it when you see it. I guess what I would say is if the work that you have departs so wildly from the original that to a common observer, they might not even know these things came from each other, then you might want to start thinking in that direction. But generally, no. If you just have a sepia tone one and a black and white one and a color one, and you adjust contrast and curves here and there, don't need to be re-registering those. The underlying file is just fine.
Tom, this is from Kat. It's an interesting question. You may not know exactly which images are being used. So that someone might use some, but not others from a collection. So does that mean that all the body of works that are purchased or selected are considered published? And if not, how do you figure that out?
So what the Copyright Office has said, and it builds a little bit on what we talked about during the presentation, but what the Copyright Office has said is that if you deliver work to a client, you deliver a group of images and you don't know what images the client's going to actually end up using, is that work published or not published? The Copyright Office has said you can consider that published. And the reason is that you took the only affirmative action that you could take in that situation. And so therefore, since you don't know what the end result is, it's not reasonable for you to try to track down how your client uses each and every image to determine publication. If you say that these images are published, the Copyright Office is going to support that given the facts. Brings up an interesting point, which is the Copyright Office, unlike trademark, unlike patent, they don't really check what you tell them. They take what you tell them as the truth. And the downside of this is that if you say to them, this work is published, they're going to just say, great, here's your certificate. And you might find out when you're in court 3 years, 5 years, 10 years later, that the Copyright Office actually says, well, given those facts, we probably would have considered that unpublished. And now you're stuck, right? Now you're in a situation where you're getting into supplemental registrations, you're getting into, having to start over, losing statutory damages, which is frustrating and terrible, and it's part of what we're trying to change. But what I wanted to say there is that you have to make a good faith effort based on everything you know, whether these things are published or unpublished. In the situation that was brought up, once you deliver that to a client, if you don't know what the client's going to do with it, and they might publish some and not all, and you don't know when, that's okay. You can consider it published as of the date of delivery, and that information comes from Rob Kucinich up at the Copyright Office.
Thanks. This one comes from Peter. I think it's something you and I have actually talked about before. The question is, if I hire photographers to work at a large event as a work for hire and retain the copyright in my name, am I the author?
So you are not the author, you are the claimant. You are the claimant. And well, this is probably easier to show than tell. So give me 1 minute here. All right. Okay. So when the question is this, according to the copyright law, and I'm going to share my screen real quick because it's easy enough to do. I'm already right here. According to copyright law, the author, when you're asked for the author's name, you give an individual name or an organization name, but not both. The author is the person who created the photograph unless the contribution was made for hire, and you've got to make sure that it is correctly made for hire. In the situation that the questioner described, you need to have a written statement that this is a work made for hire and that the person taking the photograph owns no rights in it. As long as you have that written statement and it falls into one of those 9 categories of what is allowed to be a work made for hire, hint, search on asmp.org for works made for hire and you'll find articles about it. If that's the case and it really is a work made for hire, then the employer is considered the author. But you have to make sure that you have complied with all the formalities of this, all the formalities of that, okay? Last thing I'd say about that question, remember, normally duration of copyright is the author's life plus 70 years. But if it's a work made for hire and your company owns it, the employer owns it, then it's 95 years from the date of first publication or 120 years. So it changes up the length of copyright if you are dealing with an organization or a work made for hire. And if you're a work made for hire, then essentially the authorship passes the person who snapped the picture and goes to the employer. But you got to make sure you have your ducks in a row.
Thanks, Tom. I'm going to go with this question from Christine, which is, what if you're intending to put it out there to sell yourself as a photographer, to get business, to get marketing? And I assume the question there is that published? Yeah.
So this turns on this idea of public display, right? So that in that definition I gave you, it said the mere act of public display is not considered publication, okay? That's tricky because if you're using it and you know that the images that are out there that you're putting on display are images that you would license or you would sell, or you are offering them for license or sale or further distribution, then it's likely that those are considered published, okay? If they're on your website where you sell and license images, then it's likely those are considered published. If you're putting it out there in an advertisement to sell your services, it's a little more gray, although I might argue that those would be considered published, okay? Now, you always want to make your best effort to figure out whether things are published or unpublished, but if you are 100% on the fence and you just don't know, it could be published, it could be unpublished, it's in that gray area, I want you to err on the side of published. Err on the side of published. Why? Because unpublished works get more protection than published works. And you might be thinking, well, why would I want to pick the thing that gives me less protection? The reason is that if in the future it's determined that there's a problem with your registration and you pick the wrong one, you can go from having something that's called published to unpublished, but you can't go the other direction without starting over, okay? You can't go the other direction. So if you are truly on the fence and you're not sure, err on the side of published, but use all these guidelines and try to think about where they fall. A good way to do this so that you never have a question is that you register every picture you take before you deliver it or put it online anywhere. Then it's always unpublished. Or you always register as published after you post the images to your website, and at the top of the page it says these images are available for license or sale. Then you know that everything on that page is considered published as of the date you uploaded it. That way you have no questions. You can do it before it goes out into the world and you just do everything as unpublished, or you can do it after you put it on your website or something like that. But make sure you have that little phrase or something that says, hey, these are available for license or sale. Then when you register, you know how to register. You bypass this whole question, and there's benefit in that.
Tom, I think this one is a good follow-up to that. What if you aren't sure? Could you submit some photos twice, once in each category, or is just once suffice if you don't know one way or the other?
So submitting things multiple times that are exactly the same in different categories sounds like it might be a good, safeguard, but it's not really preferred practice, right? So here, if you really don't know, err on the side of publish. Let's start there, okay? But a good way to think about this is you have options. Let's say you, right now, you file a group registration, you do it as published, and you really should have been unpublished, and you feel pretty confident. You can file a supplemental registration, is what it's called. And essentially you can change some of those things. You can change a lot of things about your registration with a supplemental registration. So, but that gets a little tricky, and you probably want to have a copyright attorney work on some of that with you. So you want to give it your best shot at the beginning. I would not recommend that you register the same batch of images as published and unpublished at the same time. I haven't talked to the Copyright Office about that. I will put it on a list so I can get their official determination. But based on everything I know, it's probably not the best idea, not to mention it costs you money. So.
Thanks. And this one from Kat. Would adding contract language to the scope of work or the estimate help with clarifying what is agreed to as published between the photographer and the client? Does that make any difference to actually have that in the SOW or the estimate, or is just the actual practice and what happens count?
Yeah. So this is a little bit like whether someone is an employee or an independent contractor. And what I mean by that is I can write in a contract, in an agreement, you are an independent contractor. But if I treat you like an employee, the state and the IRS and everyone can say, this person's really an employee. And you say, no, look, we had it in a contract. We both agreed. It doesn't really matter, right? So whether something is published or unpublished ultimately comes down to what the Copyright Office would say and a court would say. And it's more important what a court would say. Now, could language in a contract or a scope of work document or anything else, could that language be helpful in proving that you and the photographer were on the same page about how this was going to operate? Yes, it could be helpful. But in and of itself, simply saying something is published is not going to supplant what the court or the Copyright Office might say about it in the future.
Great. And this is an interesting one. If the published date is the date of the capture, how does that affect licensing terms on client agreements, which are often date of first use?
Yeah. So if the publishing date is not often the date of the capture unless you're doing some unique things, right? So if you are shooting and you are immediately uploading to some service or social media in a way that would be considered published, then it would be the same. But there are images that I took 25 years ago, the negatives that are sitting there that I've scanned in, that I've never done anything with. If I then put them on a website tomorrow, that might be considered publication, but that'd be the first publication. I could then register that as a published work with the date of first publication being tomorrow. even though I shot it 25 years ago, right? So you really have to determine the date that it was published, not the date you took it. Those can be the same, but they're not necessarily the same, right? Now, Jim, there's a second half to that question that I think I got sidetracked on.
No, I think you covered it. The
Okay.
last part you said was, you know, would it somehow help to have both, or would it affect it? And I think you totally covered that. I think.
Good.
From Michael, what if you change your file name after registration?
Yeah, doesn't matter. You know, it is a good practice, and this now comes from the lawyer part of me that says if you start changing file names after registration, you want to have some kind of idea of what it was before, right? But from a copyright standpoint, doesn't matter. The file name and the title are the name and the title that you have at the time of registration. Just like if I register my work as unpublished today and I publish it tomorrow, I don't have to re-register it as published. It's done. I'm done with it. It was that moment in time when I registered it that everything I said on that registration application was true and correct. Whether I change file names in the future is not something that would invalidate a registration. If you were really concerned about it, you could file a supplemental registration and change the file names on a registration you did in the past. Not worth the money generally to do that kind of stuff.
Tom, a little bit. I hope we got Tom. I lost you there a little bit. I don't know if anybody.
Oh no.
Oh, good.
Right.
Maybe my connection, not yours. So good. Nick, from Nick, is it possible to retroactively copyright photographs from prior years? How long have you got to do that?
What a great question. So is it possible? Yes. And how long? There really isn't a limit. I was working with an archive earlier this year, and we were doing copyright applications for works that were created in the 20s, right? You know, you can always copyright your images. Now, if you want to get statutory damages, which is, you know, those damages that aren't based on the amount of money you lost, but rather based on that kind of deterrent effect, and that's those up to 150,000 for willful infringement. If you want to get statutory damages, you have to register your work before the work is infringed. Before the work is infringed. If you see that someone infringed your work and then you go and register the next day, you're not going to be eligible for statutory damages. You're only going to be eligible for actual damages, which is why we want to register our work regularly. We want to register our work before infringements, and you're going to hear me harp on registration all year long.
This one from Barney. I stopped registering a couple of years ago when the 750 limit was imposed. I used to register whole proof sheets 1 month at a time. It's very frustrating as most projects involve hundreds of images. Can a collection of related images of similar content and style be considered as copyrighted if just one or two representatives images are registered? Or do we have to do the whole lot?
Yeah, so the answer is no. Representative images can't confer copyright onto images that aren't actually submitted. And I understand what you're saying, right? And you know, back when we could register unlimited numbers of unpublished images, there was people didn't have to kind of pick and choose, and now they have to pick and choose a little more. But I want to give you the other side of this. As Jim mentioned at the beginning, I work with a lot of visual artists, not just photographers. If you are a painter, or you are a sculptor, or you are any kind of visual artist, you get to register 10 unpublished works on one application, and that's it. And published works, you only get to do one at a time. Only one at a time. So in the whole scheme of copyright law, photographers have much better situation than other visual artists. Graphic designers suffer from the same thing I just mentioned, right? You know, if you've published things, you can't do 100 logos on an application. You got 10, so you got to file 10 applications. That 750 limit, it costs $65 to register in one of the group applications, okay? So two things you can do. One, and this is what I recommend when I work with photographers who are working on commercial projects, build that into your estimate, build that into the price so that you know going into every shoot, this is what it's going to cost to register. And then frankly, register that shoot independently, right? You don't have to wait any time. You don't have to get to 750. If you're there, great. If not, not, okay? And if the shoot you think is going to take 3 or 4 different applications, then build in that $65 times 4 to into your estimate as much as you can. Some clients I've worked for have been willing to absorb the cost of copyright registration in the same way they would some other types of materials or supplies or expenses. So that's one thought. The other thought is that you can be a little more judicious in selecting what to copyright. So as you mentioned, you have a lot of similars, right? So maybe you say, you know what, I'm keeping these similars. Maybe they're 2-star, 3-star images. I'm not getting rid of them, but they're not my hero shots in this series. I'm not sending them to a client. I'm just keeping them in the archive. And so maybe what you do then is you register the hero shots of that selection of 20, maybe you register 2. And then in the future, if there's ever any, if you have time or money or the wherewithal, you go back and re-register or register things that you skipped the first time around. But you are always registering the works that are most likely to be infringed and the ones that are going out into the world. Probably a good way to think about it.
This is an interesting one from Jason, and probably could be, although it seems narrow, it could probably be applied to a whole bunch of different situations beyond a specific one. Well, what if you're working with the Digitech and they're actually the ones who are triggering the taking of the image, and you might even expand that question to what if you're working on a large set or you're a filmmaker and you have obviously multiple people who in that case owns the copyright, and is there anything special that you need to be doing when you're working with a team, even though you consider yourself the author of it?
Yes. And here's why. And this just had a case about this the other day. A photographer had a assistant, and the assistant would come in on shoots, and the photographer said, "Hey, assistant, I'm going to pay you with a 1099. You're an independent contractor." And the assistant, they had done that for a few years, and the assistant had gone regularly to shoots. The assistant and the photographer had a falling out, and the photographer goes and sees all of their work on the assistant's website. The assistant was the one that actually hit the shutter, but wasn't the one that got the clients or anything else, and called me and said, "Hey, who owns the copyright here?" The assistant does. You don't even own the copyright to the thing that you set up with the client you obtained and the shoot that you put together. Why? Because remember, unless you have that written work for hire agreement, the author, the owner of the copyright is the person who presses the shutter, unless it is a pure work for hire. Now, this was an interesting scenario, not to go too deep down the rabbit hole, but it turns out the way this photographer was treating the assistant was actually as an employee and not as a contractor. So what we ended up doing is going to the state and saying, "Hey, state, I've misclassified this person for the last 3 years, which means I owe you penalties, money, I owe you back taxes, IRS, I owe you money and back taxes." But by doing that, because that person was an employee and was misclassified, the photographer got back all their copyrights because now it was a work for hire with an employer-employee situation. If you get in anything like that, obviously you want an attorney. That was a little tricky, right? But to answer the direct question, if you are working with a contractor, you're working on a large set, and you are not the one taking the picture, or you're not the one creating, the final, I recommend you have work for hire agreements with your assistants and your retouchers and any Digitechs and anyone else, right? Who's going to work on the work that you think you own your copyright in. Because if you don't, there's a chance that you don't own the copyrights that you think you do. And if you ever have a falling out, you might find your work somewhere else and not be able to do anything about it.
By the way, Tom, we actually have significantly more questions unanswered than we did when you started answering questions about 20 minutes ago, just to let you know that.
Jim, if you're comfortable, I'm comfortable going a while longer.
Yeah, I'm comfortable going as long as you can go. So,
Oh, that's dangerous. That's dangerous.
and I've been trying to move past those questions. Like I said, that I think you already answered in your presentation. Some fall into that category, but there's quite a few that don't. I see one here from Ben. Do you need to use Excel to fill in the spreadsheets? Ben opened the spreadsheet in Apple Numbers and got warnings, including password protection on sheets was removed, unsupported conditional highlighting rules were removed, and hidden sheets were made visible. I opened it in Google Sheets and it imported, but gave me no indication if any Excel features are not supported. Obviously, a technical question. Is that one you can answer?
Yeah. You don't have to use Excel, but if you download the Copyright Office's templates, they are going to only work right in Excel when it comes to, that color coding and highlighting and all that, right? So if you don't have Microsoft Office and you want to use this, OpenOffice is still out there, and that's a free version of an alternative to Microsoft Office. But the Copyright Office only says you have to have a sequentially numbered list, and it can be an Excel file, it can be a PDF file, it can be a Word file. It just has to have that right information. The reason I recommend using Copyright Office templates is it makes it really easy to sort and organize. It lets you know when you don't have the information in there, et cetera.
Great. This one actually is one you and I have talked about. Do we copyright video works the same way?
So no is the short answer. And this is becoming a larger and larger deal for still photographers who, as most of you are incorporating motion into your work. But motion has to be registered differently and separately from the still work. And you don't have the same types of, the idea of group registrations and things are very different on that side of the fence. You bring up a really good point, and one that I think is going to be addressed here in the next few months. And I'll be doing some articles and some programming on registering copyrights for motion, because it is different. It is different. Totally different form, totally different workflow, but equally important as everyone does more and more motion in what they do. So.
Thanks. From Ken, if one registers photos as unpublished and they are later published, do we need to re-register the photos for copyright protection, or nope?
Nope, you're good to go. As long as they were what you said they were when you registered, you're protected for the duration of the copyright period, your life plus 70 years.
Okay, a couple here I'm just dismissing because you've already answered them or in the presentation. From Nick, I now realize, oh, there we go. I now realize that my question should have been whether there is a way to register images from priors. I think you answered that, Tom, but
well, and maybe to clarify, let's say I have 500 pictures from 75 and 1,000 pictures from 82, and then 10 pictures from 83. They all have to go on separate applications if they're published, right? And they all have to go on separate applications if they're published because the calendar year rule. But other than that, you can absolutely register all of them. I don't know if that answered the question, but is there a way to use the exact same form and the exact same process that we just looked at that you would if you, for images you were photographing tomorrow?
Got it. From Kevin, in the copyright submission process where you showed adding all the file names, you entered a date in the published field. But what if you're submitting for unpublished work?
Great question. You wouldn't see that field because remember the threshold decision before you even get there was a drop down that said, is this a group of published or unpublished? I chose published. Had I chosen unpublished, you wouldn't have seen that field. It wouldn't have asked me that question.
From Daryl Ann, apologies. This hasn't come up. So it's apologies this came up, but it has not come up. I have many binders containing pages of negative strips. I'm creating a high-res digital scan of each page. Can I submit each page as an individual item i.e. 750 pages at a time versus individual frames?
Yeah, this has come up. This comes up regularly in terms of, can I submit contact sheets? Can I submit, composites of images, grids of images? The short answer is no. Really what you get when you get a copyright is you get the right in the unit that you have obtained the copyright on, right? The photograph, if you're doing a group registration, you get the right of the photograph. Now, you could argue, well, if I register a contact sheet and then it turns out that someone used one of the photographs, they've really used a portion of the thing that I had registered, and they're not allowed to do that. And the larger answer is that in practice, the Copyright Office would look at that at best as a trying to get around a limitation, and at worst as fraud, because they make their money from registrations, right? And look, let's all be clear about it. For them to survive, they have to get registration fees. And so the reason that there's a 750 limit, there's a couple reasons, but one of the reasons is that it prevents people from registering 30,000 pictures at once, because now they get some more money out of it. I mean, we all live in the real world here. So, can you do what you're saying? Remember, if you tried that, they would accept it. They would say, yes, you're good to go. But if someone ever infringed you, trying to use that to defeat an infringement would be very difficult in court.
From Omega, I'm sure you get this one a lot. What credibility does the copyright symbol hold when you're showcasing your work? What difference does it make if you have it on there or if you don't have it on there? And what's the best practice in the use of that symbol?
Okay. So, and I will do my best. I know we're going long, but I will try to not geek out on this, but give me a moment. Prior to 1978, we were under the Copyright Act of 1909. The Copyright Act of 1909 said you have to have that copyright symbol to get copyright protection. But then the Copyright Act of 1976 came along. And the Copyright Act of 1976, which is the one we're currently under now, removed the requirement that you have to have a copyright symbol to have copyright protection. So you might be thinking, well, then I don't need to have it, so it doesn't mean anything. Almost, but if you have the copyright symbol conspicuously in a caption or on the work, you are now raising the bar. If people infringe, it's more likely that they're infringing willfully or non-innocently, right? Because the copyright symbol is right there in front of their face. It's very hard for them to say, well, I didn't know, right? If it's right there. So, is it a good idea? Yes. Now, watermarks are a very personal decision, okay? Watermarks are a very personal decision. I will say this. Always have copyright information in your metadata, okay? Always make sure your metadata indicates that the work is copyrighted and have contact information for you, okay? That's important, because it's not only about the copyright symbol that people can see, it's about the copyright symbol that's in the metadata as well. If anyone removes those things, it's now a violation of copyright management information. And there's a whole section of the of copyright law called the DMCA. And we've heard of the DMCA related to safe harbor provisions, probably something you may have seen out there in the world. But there's a second part of the DMCA, which is removal of CMI, which is copyright management information. And if someone goes in and removes your name, removes your copyright symbol without your permission, there can be a lot of penalties. And by the way, those penalties under the DMCA, you don't have to have registered before the event took place. So there are a couple different things there, but DMCA is a whole different discussion. Bottom line on copyright symbol, the more you use it, the greater the likelihood that you'll be able to protect your work and call it willful infringement in the future.
Thanks, and apologies for the cat. I thought he was in another room, but apparently he made his way in here. From Jonathan, I think you kind of answered this, but I know it's an important question, so maybe more clarification. If I deliver a job to a client in January, how long do I have to register those images?
So if you want to register them, quote, timely, okay, timely, you have to have them registered before the infringement takes place. So let's say you delivered them in January and you didn't register them for till 5 years later, but an infringement took place 6 years later. You're good, you're fine, okay? There's no set time limit, but what you should think about is this little clause I haven't mentioned yet, and that is you have to register before the infringement takes place or within 3 months of first publication. It's not and, it's or. And so what that means is that let's say you deliver them in January and someone infringes on you in February. You can register them in March, which is after the infringement took place, but it's still within 3 months of first publication. So you're retroactively protected because there's a little 3-month grace period, okay? So the answer to the question that you asked is there is no functional time limit on registering work that you deliver in January to a client. But the practice that I want all of you to think about is every 3 months, register your work, and then you will always be protected, right? If you have a 3-month grace period, that means register 4 times a year at a minimum, and you're going to always be protected if you do it once a quarter, okay? This goes into your personal situation, how many images you're taking, what kind of clients you're working for, all that. But to answer your question, there's no functional limit. There is a practical limit because you want to get those things registered before they're infringed.
I'm going to take this question a little out of order because it seems to follow on it, which is, can you explain the difference between the ability to get statutory and actual damages, again, depending on when you register the work?
Yeah, absolutely. You always can get actual damages, no matter what. Now, remember, you can't go to court until you have it registered. So if I find out someone infringed me last month and I register today, what that means is I am not eligible for statutory damages because I didn't register until after the infringement. So I don't get statutory damages. I can always get actual damages, no matter when you register, okay? You can get statutory damages. And by the way, part of statutory damages are attorney's fees. Now, attorney's fees aren't mandatory, but they're permissive only if you've registered before the infringement or within 3 months of first publication, okay? So that's why this is so important. If you are limited to actual damages, you are going to be stuck with what you can actually prove, and you have to go out and find an expert who can value things and all this other stuff, right? And those are very expensive, which means that if you have a small case and you have not registered timely, again, before the infringement or within 3 months of first publication, then it's very unlikely you're going to find a lawyer who's going to take that case. The reason is that, and I saw a question alluding to this, is that copyright infringement cases take years, and that was before the pandemic, and they cost hundreds of thousands of dollars. If there is not an option to recover attorney's fees, it almost doesn't make economic sense for you to move forward with the case because you could win. And you could say, yeah, they infringed and my actual damages were $10,000 and I owe $250,000 3 years later, right, in legal fees. So you won, but you lost. So get those things registered.
Got it. Another one from Daryl Ann. If one frame of a strip was published, should I hold aside the entire strip to submit as published?
No. Remember, this isn't about similars. It's not about the same set or shoot. If you know that only one image fits into the definition of publication and images that you took immediately surrounding it do not, then those would not be considered, they're not published just because one is that looks the same. Public, copyright, it gives you protection for the actual thing you're copywriting, not the idea and not the concept and not the pose and not the lighting. It's the actual thing you're copywriting, the tangible piece of it. So I'm not sure I answered that completely, but I think the short answer is no. You only need to register as published the things that are actually published and not just things in proximity.
Tom, from David, he's the sole proprietor of an LLC. When he's registering his copyright, should he use his name or his LLC's name?
I almost made this one of my 5 tips because I think it's important. But as I started writing it out, I realized that it requires more explanation than a simple, tip in your personal name. And there are also good reasons why you might do it in your business name. For example, you might want to do it in your business name because if your business owns those assets, then that increases the valuation of your business. But you might want to do it in your personal name because if it was in your business and your business goes out of business, then you could lose all your copyrights, and that's not good. Now, here's the important part. You can very easily transfer copyright registrations between you and your business if you do it in the right way with a writing. It has to be in a writing and it has to be signed. And if you are a single member LLC, sole proprietor, whatever you are, and you sign as the business owner and the photographer, then you're good to go. Yes, you actually have to sign twice. It looks silly, but you gotta do it anyway. Now, in general, I tend to recommend that photographers register in their own names, but if you're a tax professional, if others, if your attorney, if others say, there would be a benefit here to having it in the name of the business, by all means, think about that and listen to them. This is not a hard and fast rule, and it's one you have to give some thought to. But in general, I say register it personally.
From Kat.
Sorry, I see that. Look, we got backups on backup. Can you all hear me?
Yeah.
Okay, better?
Yeah.
Okay, sorry about that. Register personally is generally what I say, but it can be in your business name if it makes more sense for you directly.
And all that question got in, Tom, in the audio. It's just the quality changed midway through. So I think everyone heard your answer, and you sound great again as always now.
Oh, good.
From Kat, and I think I'm going to get this right. I think what she means is, when should a client pay for copyright registration for a photographer, or other cases where that would take place, or why should they pay?
Sure. So in many of the type of work that you all do, this may not be reasonable at all. It just doesn't make sense. If you're editorial shooter, if you're, there are a lot of cases where this would not make sense, but there are some cases where it would make sense, right? And this is especially true if you are shooting in exclusive manners. I did some work for some of the oil and gas companies back in the day down here in Texas, and there were very strict rules about what I could do with the work and what they could do with the work, and that no one could see it, and there's proprietary information. They actually paid for copyright registrations as part of the contractual agreement we had, because I knew that there was no secondary market for this, but I still wanted to own the copyright. Okay. Now, there is also something which is happening more often, which is joint copyright ownership. And in joint copyright ownership, you, the author, can also have a shared copyright with another person or an organization. There's a whole different application process for that. It's not necessarily something that's recommended, but I have seen recently where people who hire photographers have paid for registrations when there is some level of ownership with the in the copyright itself. I think it depends on the industry you're in and what you're going to do with it. It's certainly not a hard and fast rule, and it's certainly not common, by the way. But maybe to my point earlier, you can think of it as a cost of doing business that goes into your calculation on how much you you put in for an estimate for the job, right? So, you know, just don't ignore it and then realize after the fact, oh, I have to pay a couple $100 in copyright registrations for this, you know, week-long shoot. Think about it on the front end, and maybe you can work it into your estimate as part of the kind of baseline cost of doing business.
This is going back to the earlier topic of publishing from Meg. If you're a teacher and you show your images as demonstrations in a classroom as part of a lecture or to your students, are those considered published once they're shown in class?
So generally, no. The reason is that even though you are making them available to your students to see, you're not making them available for purposes of further distribution or display. And it's not the general public. It could, not to muddy the waters, there's a really small area of copyright law that talks about limited publication. But for our purposes here in this question, that is likely not to be published. Now, every time you've heard me talk about publication status, you've heard me say likely, and you know, it's probably that. The reason is that no one, not a copyright lawyer, not any of your friends, not anyone can tell you whether or not something is published or not. It only is a court who can ultimately say, in the Copyright Office, who can ultimately say whether something is published or not. And so, you know, I can give you likelihoods with some confidence, but it's not a 100% of the time rule. It's kind of like fair use. There's no 100% of the time fair use rule.
From Dean, is an animated GIF a still or motion?
Dean, that's a great question. You know, I always say on these things that if I don't know the answer, I try not to guess at things. I honestly have not ever thought about that. And my gut instinct says that it would be a piece of motion because you would not be able to give a deposit copy that would be similar to a photograph and show you all the elements of it. But I want you to stay tuned. I will answer that in some upcoming thing. And if you shoot me an email at legal@asmp.org and remind me, it may be a few weeks or a month or two, but I will find an answer. I will, that's interesting. I want to know that. So.
From John, he says, sorry, I'm just joining and missed most of the presentation. This is actually from quite a while back in our webinar here. But he just wants to confirm if an old registration since COVID began has actually been approved or registered. Is there a way to confirm that?
Yeah, call the Copyright Office.
Okay.
Yeah. The Copyright Office gives them the information you have. If you uploaded your work after you went through the registration process, you got an email which says something like a confirmation of deposited submission or confirmation of submission or something. There should be a case number associated with that, and you might have your spreadsheet which has the case number on it. Call the Copyright Office and give them the case number, and they'll give you they'll give you an update as to where it's at.
Nancy asks, if each frame on multiple rolls of film shot on assignment have not been scanned, how can that be registered? Can you use just one or two shots? If all the negatives have not been returned, maybe the newspaper has some of those negatives. The newspaper tear sheets have also been scanned. Can you give a little more detail on how that would work?
Yeah. If you're shooting for a newspaper and you are delivering the film to them and they have the negatives and they can do what they want with it and further distribute it or publish it as they see fit, that's very similar to the example that we gave during the presentation that Rob said you can say those are published. And so now your question is how do you upload things that you might not have access to anymore? It's a little trickier, but I think you could, if you have scans of the tear sheets, that's one thing. But a primary requirement of a copyright registration is you have to provide a deposit copy of the image, which is a scan or some type of original. Back in the day, people even did prints of negatives, little work prints before scanning. And so, but if you can't provide that, then they're not going to accept the registration. So you might be in a bit of a bind with providing the deposit copy. And so you might want to see if you can track down those negatives or get them scanned or whatever the case is. I think the better idea moving forward is that you certainly don't let anything out of your possession that you don't have a deposit copy of. I know in the past that was different than it is now. In this kind of fully digital world, it's a lot easier now. But if you can't provide a deposit copy, you're going to have a hard time getting a registration.
Another question from Daryl Ann. If the photographer dies prematurely, can they legally arrange to hand off the copyright of all their material to someone else before that, so that the lifetime clock of that person, so that the lifetime clock is that of the person it was handed off to, not of the photographer who passed away?
Yeah, so without spending the next hour talking about this, which I was just dealing with the other day, the answer is no. The answer is really no. The balance in copyright law is the public domain. That is why, unlike trademarks, unlike patents, unlike some other things, there are no renewal periods in the copyright law anymore. When the time is up, the time is up. If you transfer it to a business, there are some calculations and some determinations that are made so that you don't get a double bite at the apple when it comes to duration of copyright. It's really the duration of the copyright is what it is, and then it's over. No renewals, no second chances. But your life plus 70 years isn't too short. Copyright terms used to be just in the dozens of years back in the day. And by back in the day, I mean in the 70s. You had to file for a renewal, and it was a much shorter period. So we did pretty well in the Copyright Act of 1976. And then the very weirdly named Sonny Bono Copyright Term Extension Act. Because he was the one that worked hard on it.
So. I actually think you probably answered this question in a previous way, but slightly different, asked in a slightly different way. But I'm gonna put it out to you anyway. If you're on a photo team, whose lifetime is the copyright based on? The person that lives the longest? I'm going to assume, based on your earlier answer, it'd be the person who actually took the shot. But what is it, Tom?
So there's kind of two options. If the work is registered in the name of an individual, then it's the life of the individual. If the work is registered in the name of the business or the team, right, then it is that 95 or 120 year clock. Either way, the term of copyright is not based on the number of people in the company. It's based on how it was registered, and how it's registered is based on who shot it and was there a work for hire agreement or some other written agreement, things like that.
Tom, from Amy, this is a good question for a lawyer. Is it worth it to pay for the businesses that provide copyright submission services, or for legal offices that offer to submit all copyrights and enforce them? Or should I just do it myself?
So copyright is designed for you to be able to do it yourself without the help of a lawyer. Okay. Trademarks are not, patents are definitely not, okay? But copyright is. Now, that being said, there are a lot of companies that offer to do this. And I know a lot of photographers have had good experiences. I am very wary of some of these companies, okay? Because generally what they're saying is that we will do your copyrights if we find an infringement, you let us go and track down that infringement. And then if we get any money, we get 50% of it. There are some companies like that that are great. And there are some that are shady, and I wouldn't want any ASMP member to touch with a 10-foot pole. Now, that is likely going to be something that I'm going to dive more into this year. But to answer the question that you pose, I think it is one of those skill sets that every photographer should have to feel confident in registering their own copyrights. And you shouldn't have to pay anyone to do it for you. You can, of course, you can go find a lawyer, you can find these companies, but you want to be real careful about that because you don't want to get into a situation that is surprising. I'll give you one example. I know a company, this is not a recent story, but a company went out of business. But one of the things that they did was they would register people's copyrights, except in the fine print it said, oh, we also own part of the copyright as a joint copyright, and you agree to that kind of thing. You want to be real careful about that. It's like those shady contests and things like that. So I think you should learn how to do it yourself, and the tools at ASMP should help get you there.
Tom, from David, when registering public work from 20 years ago, but you can't confirm the exact day or month it was published, just the year or even the rough year, what do I list as the published date?
Yeah. The trick here is a good faith effort based on whatever you can piece together. You know, again, it's not like the copyright police are going to come to your door, but you also don't want to say, oh, I just remember I took it and I just picked some random day, right? So you think about the year and then maybe you say, okay, January 15th, you know, I think is about when I took it. It looks like it was in the winter, whatever the case is. Just have a good faith guess, a good faith effort behind it. Do what you can do with it. You don't have to become an image archaeologist and figure out exactly when something was taken, but you want to give it your best shot, and most of the time that's going to be okay for
you. Tom, from Kat, are there benefits to the end user, like an agency, in registering an image after substantial retouching or digital imaging, or is it still considered a derivative work, or is it case by case?
It's really case by case, but the difference between derivative works and transformative works is really in flux right now, really in flux. And if you are an agency looking to protect yourself, there should be kind of a set of guidelines that you have internally as to when it might cross that line and when you might want to register the work as a new work or as part of a different kind of collection or compilation. And, you know, there's some things to think about. When I work with businesses on strategy like that, it is case by case, and we sit down and look at, hey, what's happening from point A to point Z, and at what point in there does it make sense that this thing has become something new? Remember, transformational use and the fair use side is all about new message or meaning. When things are imbued with new message or meaning, maybe they stop becoming derivative works as easily. It's not just about what it looks like. Sometimes it's about what it means or what it's conveying.
From Michael, let's say you have 500 images. The file names exceed 1,995 characters. Do you need to create a new case number, or do you just add multiple lines to include the number of images to each line so as not to exceed the character limit?
What you would do if you wanted to include all of them is you would create multiple titles, right? And add them. But, I think it's fair to say that if you are doing that, that box isn't going to hold all of the characters that you need to name all those various images. And just having them there, and if these images are numbered sequentially, even if it's only the first 2,000 characters that are on there, sometimes that gets across what you need to get across. But you can add in all the titles with multiple line items, adding in new sets of titles. So.
Kyle asks, with regard to the requirement that you register the copyright in advance of the infringement, does the infringement occur when the actual act happened or when you find the infringement?
So some of these questions are so much fun because this implicates a rule in copyright law. It's in other parts of law too, but it's the discovery rule. When does the injury take place? When does the action take place? When it occurs or when you find out it occurs, right? And this actually is not a settled question. If you live in one state, it might be one thing, and in a different state, it's something else. The majority of circuits, the majority of jurisdictions hold to the discovery rule, which is the injury occurs, the statute of limitations starts running from the time you discover the infringement. Now, also on statute of limitations, you have 3 years to bring your infringement claim. And again, most of the jurisdictions say it's from the time of discovery, not the time that it actually occurred. But there are some places, there are some courts that work off the actual damage and not the discovery rule, but by and large, it's from when you discover that an infringement has occurred.
From Omega, is it unethical to use the copyright symbol on an unregistered photo, especially on social media, with the intent of protecting your work, or worse, is it illegal to do so?
Oh, what a good question. Absolutely not. It is not only not unethical, it is absolutely appropriate. Why? Remember, very first thing I started with, you own the copyright in your work the minute you press that shutter. That means that from the minute you take the picture, you can put that copyright symbol anywhere and everywhere, and it is not illegal, and it is not unethical, and it's exactly accurate, and it's 100% of the time the right thing to do. Now, this is different than a trademark. When you have a trademark, you can put the little TM up there, which means that you're intending to get a trademark. And then when it's actually registered, you can put the R with a circle. If you put the R with a circle before you actually get it registered, that's not allowed. That's illegal. I mean, illegal is a weird word for that, but it's not allowed, right? Copyright, totally different, because registering the copyright doesn't give you more rights. You own that copyright from the minute of creation, the minute you press that shutter. So go and use that copyright symbol as much as you want, feeling good about it.
From Nancy, should images registered in digital contact sheets when unlimited numbers were allowed be resubmitted individually? And what is the consequence of registering an image twice?
That's a good question, Nancy. And so the first part of the question, digital contact sheets, I think it's going to be dependent on, this sounds really weird, what year it was registered, because the registration policies change, and what compendium, which is the rules that the Copyright Office used, was in force at the time. So one thing I'd want to know is kind of what year or what decade these things are registered, to know if you might want to do something. My gut says you don't need to do anything, although again, I think it's fact specific. I don't want to learn a little more. The danger you run into, and it's a weird kind of high level danger, is that there's a lot of stuff in copyright law that says if any of the information you're providing is knowingly invalid, then it can be considered fraud on the Copyright Office and not in good faith, and that affects a lot of things. So I think there's an argument that could be made that if you submit something in two ways that are opposite from each other, that you know one of those isn't right, right? You don't want to get into that mess. Now, very likely, they might say, well, this registration's invalid and kicked out, and this one's just fine. But there might be more to it than that. I haven't run into a case recently that's dealt with that. I'm sure they're out there, but I'm more worried there about the appearance of how it looks instead of how it actually is. But if you know you did something wrong back in the day, in a lot of cases, you can file a supplemental registration, and correct those things. And then it's not re-registering and it's not fraud. In fact, it's the opposite. It's trying to make things right. So that's always an option as well.
From Cheryl, if you have a published how-to book registered with the Library of Congress and have a copyright number, are the photos contained in the book copyrighted as well, or would those photos have to be registered independently?
So a little fact specific, and I need a little more info, but as a general rule, those are separate things, right? What happens if I go to register a book that has photos in it? It's going to ask me, are there photos in your books, or 2D drawings or 3D things or whatever? And I have to say, yes, there are. And then I have to say if I'm the author or not, right? Of the photographs, not the book. You can get a book copyrighted and get a copyright number, but that does not confer copyright in the photos themselves. All it actually is doing is conferring copyright in what you created. You can also disclaim parts of a copyright. So you can say, hey, I did this book, but I didn't do the photographs and I didn't do XYZ. And so I only want to copyright in the things that I did, right? That's where you get a lot into joint copyrights and joint authorship. That's also where you might want to start seeking out the help of an attorney in copyright, because frankly, in the whole copyright world, doing groups of photos is really easy. Getting into those situations where you have to start disclaiming parts of a copyright can get a little tricky. But to answer the underlying question, if you have a book that has a copyright and you did not take those photos in there, those photos are definitely not copyrighted and owned by you. And even if you did take them, those photos are likely not copyrighted on their own. I would register them separately from the book.
Tom, there's a number of questions on here that are of the same theme, which is what's the proper form of using the copyright logo? Do you put your name first, the year first, the copyright logo first? Are there commas in between them, semicolons? Yeah. Does it matter how you do it?
So a few things. If you're on a Mac, the copyright symbol is Option G, just FYI. And I always did a copyright symbol, year, name. Now, that is, there are no specific rules about that. Remember, the formalities for copyright symbol were extinguished in 1978. So if it's on there in any way, you're good to go. You don't have to have the year. You don't have to have your name. In fact, like I mentioned, you don't have to have anything at all, and you still have your copyright protection. But, if you're asking me how I've always done it, it's been copyright symbol, year, name.
From Andy, what is the minimum file size for the reference JPEGs?
Yeah, so I used to say, and I actually changed this in 2020, my advice on this. I used to say that it was like, 500 pixels on the long side or something like that. But I saw more and more court cases where the images at issue are being blown up and used as exhibits and shown to a jury or something else. And so I think you can go larger now. You get 650 megabytes to work with in uploads. And you only have 750 images. And so, you can make a pretty large JPEG out of that. But I think right now, you know, if I'm doing them, I'm looking at about, you know, 1,500 pixels on the long side for my deposit copy. I see people do a lot more. I don't think you need to do anything, you know, you certainly don't need to do full res images. You certainly, you know, it's actually more important that the image pixel size is larger and the quality can be less, right? You don't need to do JPEGs at like a 12. You might do them at like a 6 with a, you know, 1,500 on the long edge kind of thing. That's just that. None of what I just said is a rule. It's just what I'm kind of recommending at the moment.
This question is, so we no longer have to provide tear sheets of published work, question mark. If I copyrighted a published picture with a group of unpublished, can I now register the image as published with the year, even though it was published in 1989 and also published later without any copyright on the picture? Do you get that question, Tom, or do you want
Yeah. So you don't need a tear sheet to prove publication. You only need the image and your assertion when it was published. And the Copyright Office says, I trust you on that. If you incorrectly registered something in the past and it was actually published and you need to re-register it now as a published work, you would put the date of first publication as whatever the date was way back in the past. That would be fine, right? You know, depending on the situation, you might be able to do a supplemental registration, but it sounds like that might not be the right solution there. You'd want to have a little more advice on that before you acted on it. I think I answered that. I don't know if there's any other parts of it, but I think I got it.
A question saying, I'm confused about the 1976 law removing copyright or the copyright requirement on images, but what about prior to 78 and having to have copyright on an image? My pictures were shot in 1977, but not published until after 1978. What's the rule on that?
Yeah, that's a tricky one. And it's only tricky because you're straddling that line of when a lot of changes in copyright law were occurring, right? This is one of those few situations where, you know, a minute ago I said, hey, you can do copyright registrations yourself. You don't need a lawyer or anything. This is probably a good situation to, you know, find a copyright attorney, say, hey, I need 30, 45 minutes of your time. And here's my situation, and take a look and tell me exactly, because it can get a little tricky, when you're right in that kind of 75, 76, 77, 78 year range, making sure that all the rules comply. And especially if you shot it at one time and you publish it at a different time, and those two time periods were separate around the statute, it could be something you just probably want to have another set of eyes look at it.
Tom, here are a few questions about what counts as published. Does it count as published if it's in a blog?
Well, so again, if it is on your personal website, on your blog, your travel blog, where you're talking about cool things you did in life, then likely not, because it is you're not providing it to the general public for further distribution or sale. Now, you could argue that because it's online at all, people will get copies of it because it has to go into the cache on their computer when they visit the website. But I think it would be likely not published. What if your blog, though, is a blog on your commercial photography website and you're talking about a shoot that you did? Well, then maybe it's probably more likely to be considered published. What if your blog is a blog post saying, hey, here's what I shot in August, and if you love any of the pictures, I'll make you prints, and there's a sale going on? That's pretty close to almost always being published. So simply being a blog isn't, just like social media, just like anything, none of those are hard and fast rules. It depends on how you're using them and instead of the medium that they're in.
And a number of questions from Daryl Ann. What about if it's shown in a gallery? You know, like a gallery.
So the Copyright Office has said public display, including appearing in a gallery, is not considered publication. But what if it's in a gallery and it's for sale? Is it still publication or not? You know, there's a couple ways you could look at that. But if it's simply appearing in a gallery, then it is not considered published. The Copyright Office has actually said that specifically. That's why you're not hearing me say likely. If it is in a gallery show and there's an invitation sent out and below your image it says, you know, the price for it, I think that's publication, right? Now you're in kind of a different medium. It's being sent out to the whole world, and it's being sent out for further distribution or public display. So that's likely to be published, okay? But very, very specifically, the Copyright Office has said one image, one fine art image appearing in a gallery is not publication in and of itself.
This sort of a variation on that. What if it's in a poster of the gallery exhibit, or a card that's mailed out? I think that's what you just answered. Or how about if it's in the catalog for an exhibit? It's not a catalog that's for sale, or it's not a work of art that's for sale, but it's in a book that's available of images shown at the exhibition or at the gallery.
Yeah.
How about any of those circumstances?
The more the image is used in those ways, the more likely it is to be considered published. But the way that I might look at it is you know, if this image is being put out into the world for sale or for further distribution, then you're erring more towards published. If it's simply a public display and your name is at the bottom, then it's erring more towards not published. Every time it's in a different media, and every time it's there are actually some fine art exceptions and some other things that we really can't get into today. But it sounds like there might be some more questions about that, and I can do some more stuff about that in the future. But you know, that's the way I would look at it. Simply hanging in one place with your name is likely not published. In a catalog, on a mailer, you know, on a poster. Now you're getting more and more towards things that might be considered publication.
I'm going to read this question from Peter exactly as it's written, which is delivered charity work considered published?
So charity work makes no difference for anything. The publication is determined without any regard to who it's being delivered to, right? So the question is about even if no one paid for it and you're delivering it, and the person you're delivering it to, who you shot for free, maybe, if I'm reading the question right, is now going to use it for further distribution or display, then then that's published. And if they are not going to, then it might not be published. But as we saw in many cases, not all, in many cases, when you deliver your work to a client and you don't know how the client's going to use it, the Copyright Office accepts the premise that you can say that work is published.
From Jason, during an infringement case, you said it can take years and cost a great deal of money. So how do lawyers typically bill during that process? What can a photographer expect to experience during a case?
Yeah, so by and large, for photographers, copyright infringement cases are done on a contingency basis, where the lawyers will work on the case, and if there is a settlement or if there is a jury verdict and judgment, then the lawyer will take a percentage of the money that is collected. If no money is ever collected, then the lawyer doesn't get paid anything. That's why lawyers are cautious about the types of cases that they will take on. Because it takes so long, because it costs so much, it's sometimes very hard to find a lawyer to take your case, okay? Or a reputable lawyer to take your case. Now, this is something, and if you didn't get to watch our Case Act webinar from a week ago or 2 weeks ago, the Case Act was all about the fact that it costs too much money and it takes too long to enforce your copyright claims. So the Case Act, which passed in December and ASMP had worked on for many years, creates the Copyright Claims Board, which allows small claims copyright cases to be heard where you don't even need a lawyer. In fact, there's a provision in there that allows for law students to represent you on a pro bono basis if you're around a law school that has a clinic that does this type of stuff. It's all going to be virtual. It's made so that we can bypass some of the problems with the current system. And the largest problem with the current system is it takes too long and it costs too much. And everyone's aware of it, and that's why we're trying to find solutions to it.
From Suzanne, I'm a little confused about the quote within 3 months quote rule for published images, specifically what forms to use. For example, let's say I have 750 photos taken 30 days ago. 5 of them have been published. Am I able to submit them all in the unpublished form as long as I'm still in the 3 months, or do I need to put the 5 on a separate published form?
So you would need to put the 5 on a separate published form. And even though you get that grace period in case there's an infringement in that 3 months, right, where you get the benefits of it being unpublished, even though it's actually been published, that doesn't change the facts at the time of registration. If at the time of registration, 5 of them were published and the rest were unpublished, you would do 2 separate applications, one for the published, one for the unpublished. Again, best practice, what I'd recommend, depending on what type of business you're in, best practice would be to register all of them together as unpublished before they go anywhere else, right? Go through and do an initial edit and get rid of the out of focus ones and all the ones that you would throw away anyway. Register all the rest as unpublished, and then go about your life and be happy about it. And then you don't have to worry about some of this stuff. If the type of work you do, you take a lot of images or it's just not feasible to do that, then you have to think about how you track these things and review them. But to answer your question, you always want to make sure that at the time of registration, you are filling out those forms with the accurate truth of the images at the moment.
Tom, we have 2 more, and when we get to the end of these, if anybody thinks that I did not include a question or dismissed a question that I thought you had answered, but they still feel it's not answered, please submit it here at the end and we can tackle it. So from Andy, is there a minimum or guideline for resolution of deposited images?
There's not a there is a guideline on the Copyright Office website, and I forget what it is off the top of my head. Again, my guideline is somewhere around 1,500 pixels on the long side, and somewhere JPEG quality 6 to 8, somewhere in that range. The only rule is that it has to be visually identifiable to associate it with the actual image that you're registering. After that, I think there is an upload recommendation on the copyright website, but I honestly don't remember off the top of my head what it is. It should be pretty easy to find. And if you don't find one, you can feel safe with that, around 1,500 pixels and that quality level generally.
One more got added, but I'm going to go to the one from Jason first. What's the procedure if I own an S Corp or LLC? Legally, the corporation pays me and the client is billed by and pays the corporation. Do I register as myself and own the copyright, or as the LLC or S Corp?
Tricky stuff, and you want to be careful here, okay? The general, if you have an S Corp, and you remember, one of the first things related to an S Corp is that you have to pay yourself a quote reasonable wage. And that can be interpreted to mean that you are an employee of your S Corp, and you get W-2, which means that unless you have a written document otherwise, it could be argued that you actually never own your copyrights. They're always owned by the company. It's an argument that I've seen made. And if that were to be the case, then you would have to have that written document that says, hey, even though I have the business dealings over here, the S Corp and the W-2s and things, I personally own my copyrights in the work that's created. The bottom line there is that if you are treating yourself as an employee in an S Corp, you need to be very aware of work for hire issues and written transfer agreement issues. Worth reaching out and getting some more information on from a professional on that one, depending on, you know, how comfortable you are with what I just said.
Tom, Kevin wants to know if you'll be discussing social media terms of service and copyright protections in a future presentation.
I absolutely will. I absolutely will. And lots of things coming up there in the future. I was actually just talking with, I think y'all may have seen the Sinclair versus Mashable case settled the other day. Talking with those attorneys about their experiences, some other things that are coming up in the world related to the social media terms of service and copyright issues. And of course, we're going to stay on top of it. I'll wrap up by saying thank you for all the questions. This was a nice break today because I spent all morning writing an amicus brief that we're submitting in the Ninth Circuit on a copyright case, which says that the holding that the court said was you're only eligible for one statutory damage, even in all these downstream infringements, right? And you can imagine in a photography situation, one person infringes your work and then they pass it on to all these other people, and the age of social media goes everywhere, and then you go find all those people and they say, oh, you only get one damage for that. You're only damaged once. And so we don't like that. We're gonna I wrote an amicus brief that's being edited right now so that we can get in there and fight for that and hold those infringers to account. So had a lot of fun today. Thank you all for all the questions.
Thank you, Tom. Thanks so much. I just want to say you do as a fellow attorney, I want to say you do a phenomenal job of answering an incredibly wide array of questions without a lot of legal mumbo jumbo. I think anybody listening to your presentation would not have to have gone to law school or have any legal training to get the benefit of it. And that's a real skill. And thank you so much for that.
Oh, absolutely. That's that, you know, I always try to remember that first meeting I had with my first lawyer when I was a photographer, not knowing anything about anything. And I never want ASMP members to feel that way. So that's the goal.
Thank you. Thanks, Tom. And thanks everyone for joining us. And we look forward to the next one.
Great. See y'all later.